Registrar, please mention the matter.
Thank you, Honorable Vice President. Honorable Vice President, this is a sitting of the court for the delivery of judgment and application 006 of 2013, Wilfred, Onyango, and 9 others versus the United Republic of Tanzania. Honorable Vice President, both parties are present and are represented by counsel. Thank you, Honorable President.
Thank you, Mr. President. For the records, may we know who is for the applicant?
Much obliged, my lady. Counsel for the applicant are Evelyn Chijarira, assisted by Mr. Madinu Shangurusi Minega and Abia Kasmani. Thank you.
Thank you. Respondent?
May it please you, my lady. My name is Mark Mulwambo, Principal State Attorney for the respondent.
Thank you very much. The judgment of the court will be read by my brother, Judge Ugegus.
Thank you, Madam Vice President. Assalamu alaikum. I will start by indicating that this judgment consists of 56 pages, and that for the sake of brevity, I will not read it in its entirety. I will only read the most relevant parts thereof. The whole judgment will be available on the website of the court after the closure of this public sitting. Here is the judgment of the court. The court, composed of Elsie Thompson, Vice President, Gérard Onyango, Fatsa Ugegus, Duncan Tambala, Sylvain Auré, Ben Kyoko, Rafa Ben Ashur, Solomi Bossa and Angelo Matuse, judges, and Nuhu Diallo, Deputy Registrar. In accordance with Article 22 of the Protocol on the establishment of the African Court on Human and People's Rights, and Rule 8, Paragraph 2 of the Rules of Court, Judge Augustino Ramadi, President of the Court and a national of Tanzania, did not hear the application. In the matter of Wilfred, Onyango, Ngani, and 9 others, represented by the Pan-African Lawyers Union, itself represented by Donald Deya, counsel, versus the United Republic of Tanzania, represented inter alia by Ambassador Irene Kazien Yu, Head of Legal Division, Ministry of Foreign Affairs and International Cooperation, and Ms. Sarah Mbeipopo, Acting Deputy Attorney General, Director of Constitutional Affairs and Human Rights, Attorney General Chambers. After deliberations, the court delivers the following unanimous judgment. Part 1, the parties. The application was filed on 23rd July 2013 by Wilfred Onyango Ngani, Peter Mburu, Jimmy Njoroge, Patrick Muritir, Simon Kariuki, Boniface Mburu, David Mburu, Michael Batigo, Gabriel Kariuki, and Simon Kiambuti, hereafter referred to as the applicants. All citizens of the Republic of Kenya. The application was filed against the United Republic of Tanzania, hereafter referred to as the respondent. Part 2, subject matter of the application. The applicants alleged that they were in Mozambique exploring business opportunities when on 16 December 2005, they were without lawful resort to legal measures of extradition, kidnapped and arrested by the Mozambican police in collaboration with the Kenyan and Tanzanian police forces after a false report made by a lady by name Memuna Salimo for being linked to dangerous elements of the Kenyan military forces and Kenya administration police. They also allege that thereafter they were put on a military airplane referred to as Buffalo, bound for Tanzania. The applicants further claim that they were eventually charged for a range of serious criminal offenses, which trial has been unduly and inordinately delayed and with multiple violations of human rights. According to them, 2 of the charges were later withdrawn by the respondent, that is, criminal case number 647 of 2006 and criminal case 881 of 2006, and the respondent entered a nolle prosequi in respect of the dropped murder charge in criminal case 10 of 2008 in accordance with the provisions of section 91 of the Criminal Procedure Act of the respondent state. They submit that three of the applicants were released after the murder charge was withdrawn for lack of evidence. 5 of them were subsequently convicted for conspiracy to commit an offense, contrary to section 384 of the Penal Code, and armed robbery. They were sentenced to 30 years in prison and are currently serving their sentence at Ukonga Central Prison at Dar es Salaam, while two of them died in detention in the course of the trial. Part 3, proceedings before the national courts of Tanzania. The applicant brings the application before this court on the basis of criminal case 2 of 2006. That is, conspiracy to commit an offense, contrary to section 384 of the Penal Code, and armed robbery, contrary to section 287A of the Penal Code, at the Resident Magistrate Court, Moshi, and criminal case 10 of 2006, murder, at the High Court of Tanzania. Before this case could be heard, the applicant filed miscellaneous criminal application 7 of 2006 at the High Court of Tanzania to request for leave to file orders of certiorari and prohibition in order to challenge their alleged forceful kidnapping and abduction from Mozambique. On 1st June 2006, the High Court of Tanzania granted the applicants leave to apply for orders of certiorari and prohibition, but declined to order stay of proceedings. After the grant by the High Court, the applicants filed criminal application 16 of 2006 to request for prerogative orders of certiorari and prohibition. At the same time, the respondent state filed criminal appeal 276 of 2006 against the High Court decision in criminal application number 7 of 2006, which granted leave to the applicants to file for orders of certiorari and prohibition. Proceedings in criminal application 16 of 2006 were therefore stayed pending the results of the respondent state's appeal. On 20th November 2007, the Court of Appeal struck out the respondent's criminal appeal 276 of 2006, and this decision enabled criminal application 16 of 2006 to proceed. On 26 September 2008, the High Court dismissed in its totality criminal application 16 of 2006. On 26 November 2008, the applicants appealed this decision of the High Court to the Court of Appeal in Criminal Appeal 353 of 2008, and on 14 February 2011, the appeal was struck out for being incompetent as the appellants had not obtained leave to appeal. The applicants then filed a fresh appeal to the Court of Appeal in Criminal Case Appeal 27 of 2011. The Court of Appeal allowed the appeal on 19 March 2013 on the basis that the trial High Court judge erred in deciding the case on the merits without ruling on the preliminary points of law raised by the respondent. The case was therefore remitted back to the High Court for a decision on the preliminary points of law. The applicants aver that thereafter they filed an application before this court, arguing that they had exhausted local remedies as, I quote, A, on the criminal charges, there have been an inordinate delay of 7 years before their case has been brought to trial, and B, on the violation of their rights, the application has gone up to the Court of Appeal, end of quote. The applicants also point out that the application have proceeded all the way to the Court of Appeal twice, both times without success. To that extent, they argue that within the judicial system of the respondent, they have exhausted all local remedies. Furthermore, they allege that the Court of Appeal of the respondent, I quote, ought to have treated the repeated applications with the objective of obtaining substantive justice in the matter without undue regard to technicalities of the law, especially of the procedural law, end of quote. In conclusion, the applicants maintain that they only brought the application to this court after they realized that the respondent was taking too long to initiate the proceedings directed by the Court of Appeal in case 79 of 2011. Part 4, alleged violations. In their application, the applicants alleged the following, I quote, A, that our rights of properties were violated by the respondent state. B, that our rights of freedom were violated by the respondent state. C, that our rights of work were violated by the respondent state. And D, that our rights to be tried within a reasonable time by the courts were violated by the respondent state. End of quote. Part 6, priors of the parties. I will start with the applicants' priors. In the application of 23rd July 2013, the applicants, I quote, prayed to the African Court on Human and People's Rights to regain these rights which were violated by the respondent states. They also prayed for A, restoration of their rights which were violated with regard to the allegation made in the application, and B, an order for reparation to remedy the violations with regards to the allegations made in the application. In their reply of 31st March 2014 to the respondent's response to the application, the applicants emphasized that their main complaint is the delay by the respondent in dealing with the matters they are facing within the national justice system, being criminal case number 2 of 2006 and criminal application number 16 of 2006. They state that even though they have made a number of applications to stay proceedings against them, none of these applications was granted. It is therefore not an excuse for the respondent to delay their trial on the basis of applications they made, because no stay was ever granted in their applications. At the public hearing on 21st May 2015, the applicants prayed the court for 1, a declaration that the respondent state has violated their rights to be tried within a reasonable time as it required by Article 7 of the African Charter. 2, a declaration that the respondent state has violated their rights to be afforded legal aid and representation for the entire duration of the trial. 3. An order of this court that the pending case be concluded within a reasonable time as the court may determine. 4. A further order that the court orders that the respondent state provides legal aid and representation to the applicants for the remainder of the appeal within the national courts. 5. Reparation should follow a decision of this court pursuant the present proceedings if it goes in their favor. And 6. Any other declaration and/or orders that this honorable court may deem fit in the circumstances. End of quote. I'm coming now to the respondent's prayers. In its response to the application, the respondent raised preliminary objections with regard to the jurisdiction of the court and on the admissibility of the application. It also submitted on the merits of the application. In its response, the respondent prayed the court to grant the following orders with respect to the admissibility of the application. I quote, 1. That the application has not evoked the jurisdiction of the court. 2. That the applicants have no locus standi to file the application before the court and hence should be denied access to the court as per Article 34.6 and 5.3 of the protocol. 3. That the application has not met the admissibility requirements stipulated under Rule 50 of the rules, nor Article 56 and Article 6. Paragraph 2 of the protocol. 4. That the application has not met the mandatory procedural requirement stipulated in Rule 34, Paragraph 1 of the Rules of Court. 5. That the application be dismissed in accordance to Rule 38 of the Rules of Court. And 6. That the cost of this application be borne by the applicants. With respect to the merit of the application, the respondent prayed the court to grant the following orders. I quote, 1. That the Tanzanian police did not forcefully kidnap and abduct the applicants in collusion with Mozambican and Kenyan police officers. 2. That the respondent complied with the mandatory requirements of Section 13 of the CPA. 3. That the government of the United Republic of Tanzania has not violated the applicant's rights to own property. 4. That the government of the United Republic of Tanzania has not violated the applicant's rights to freedom. 5. That the government of the United Republic of Tanzania has not violated the applicant's right to work. 6. That the government of the United Republic of Tanzania has not violated the applicant's right to be tried within a reasonable time. 7. That the applicants not to be awarded any reparations with regard to claims and allegations made in this application against the United Republic of Tanzania. And 8, that the cost of this application be borne by the applicants. End of quote. At the public hearing, the respondent state made the following prayers. 1, I quote, a declaration that the respondent state has not caused an inordinate delay in the matters facing the applicants in criminal case 2006 and 16. 2, an order of not awarding reparations. And 3, that the application be dismissed. End of quote. Pursuant to Rule 39, Paragraph 1 of the Rules of Court, the court will deal with the questions of its jurisdiction and admissibility of the application. If the case arises, the court will then examine the merits of the matter. Part 7. Jurisdiction of the court. We'll start with the jurisdiction ratione materie, or material jurisdiction. According to the respondent, the jurisdiction of the court, as elaborated in the protocol and in the rules of court, has not been invoked by the applicants. The respondent avers that the applicants have merely cited ongoing cases against them within the national judicial system and have made no attempt to even mention the protocol, the African Charter on Human and People's Rights, or any other relevant human